Okay, good morning. Time now a minute after 8 o'clock in the morning in Tokyo, Friday, March 25th, 2022. Welcome to another edition of Morning Seminar organized by the World Bank Tokyo office. My name is Koichi Omori. I am Senior External Affairs Officer of the World Bank based in Tokyo. We are kicking off the 2022 spring semester of our morning seminar program today after taking a short break in the past several weeks. Currently, the World Bank Group is running a Japanese national recruitment program, hiring 7 junior professional officers positions and 8 mid-career positions. We are really appreciative to the government of Japan for their generous support in funding those positions. One of the 15 positions currently advertised as mid-career positions and JPOs is the mid-career counsel position at International Center for Settlement of Investment Dispute, ICSID in short, at the World Bank Group. This morning, grabbing this as a precious opportunity, we are extremely pleased to have Meg Kinnear, Secretary General of ICSID, as our keynote speaker connecting from Washington. Good evening, good morning to you, Meg. How are you?
Very good. Nice to see you.
Great. Thank you very much. In fact, we organized a seminar featuring Meg in a face-to-face manner at the office during her visit to Tokyo in 2016. I think that was the very first time to feature the ICSID in a morning seminar or in a seminar program in general. We would definitely like to continue this as a good tradition, having more of those seminars so we can enhance our understanding on what ICSID does. We'll listen to Meg for next 30-40 minutes to introduce ICSID. Then I'll read your questions as we received several questions from our audience already. Thank you very much for sending your question. If you did not have opportunities to send your question in advance, please send through online form posted on the announcement page of the seminar, or you can simply post your question on the chat section on the YouTube screen. I'll read your question, asking Meg to respond after her keynote presentation. With that, I'd like to formally ask Meg to come in to start your presentation. Meg, please.
Thank you very much. I'm delighted to join you today and to join colleagues in Tokyo. As you said, I was in Tokyo in 2016 and started to get to know some of the legal professionals. And one of the things that's very exciting is this whole field of investment arbitration is growing. And I think Japan is starting to really get some expertise in the area. And I know there was a lot of enthusiasm about it. So that makes it extra special for me to be able to present today. What I thought I would do this morning is go through a little bit about ICSID and what ICSID is as an organization and what we do. And then I wanted to bridge into what an ICSID legal counsel does, so that if people are interested in applying for this job opportunity, you'll know what the expectations are and you'll know what you should expect. I have to say, I think it's a fantastic opportunity, and we are absolutely so delighted that the government of Japan is making this available. I think it's a great opportunity for ICSID, and it's also a great opportunity for whoever fills the position. It is a very exciting time in investment arbitration. It's an incredibly exciting time at ICSID. And I'll tell you a little bit about why, but I think the timing is great and the opportunity is wonderful. So we're really looking forward to having somebody come and be with us at the center and be a part of all of our work. So let me, if I may, I did a little PowerPoint and I wanted to share it as I speak about ICSID so that it will help, I think, at least illustrate some of the points that I wanted to make. A lot of people do not know what ICSID is, but those who know what investment arbitration is and investor state law know that ICSID is very much the center of all of this endeavor and a very exciting place to be. ICSID was essentially, allow me here if I can, the reason for ICSID, and I think it's important to go back to a little bit of history, not ancient history, but the reason for ICSID was that in the late 1950s, early 1960s, a lot of countries were talking about how can you increase foreign investment into your country. People knew that you could not have government support all of this and that you needed the private sector to come in, not only to set up industries, but also bring technology, to bring jobs, to bring tax base, that this was all part of something that was a goal for many economies to help them increase investment and increase well-being. And as part of this, what they realized was that frequently where there was a dispute between a foreign investor and the country that they came to invest in, there was really no good way to resolve that. And over time, they realized that was starting to be a disincentive to investment and was actually preventing people or industries who wanted to come into a country from coming into the country, and also preventing them from either expanding or staying in the country. So it's not just attracting foreign investment, but also retaining foreign investment. And what was realized fairly quickly was that the World Bank could play a role in that by providing an impartial institution that would administer dispute resolution. And that was essentially the nugget of the idea for ICSID. And it was negotiated among the executive directors of the World Bank, and it came into fruition in October of 1966, with the first 20 states signing what's known as the ICSID Convention. And that's basically the framework convention for everything we do and for our rules. And it is in itself an international convention that also brings into effect the ICSID Secretariat and ICSID as an organization or an institution. Now, it was created as part of the World Bank Group. So when you look at the World Bank Group, there are 5 institutions. You have ICSID, IBRD, which is the bigger one that I think we all speak of as World Bank, the IDA, International Development Association, IFC, and MIGA. And each of those has obviously different mandates or different missions, all of them going towards the bigger goal of shared prosperity and addressing poverty throughout the world. Interestingly, all of the other 4 institutions of the World Bank are basically financial organizations. They do things like provide loans or lending funds to governments or providing technical assistance that will help stimulate private sector investment, or for example, MIGA giving guarantees to investors. So they really are organizations that have policies and that provide financial products in the large part. ICSID is very different from that in that it is really a non-financial organization. We don't provide loans or guarantees or any of that kind of thing. We are much more of a legal organization, and our mandate is to provide facilities for conciliation and arbitration of international investment disputes. So while the mandate or how we address our mandate is very different from the rest of the World Bank, all of this leads to the bigger purpose of addressing development and well-being of populations. Because ICSID had a different role and a different profile, there were a number of unique features that were designed as part of the ICSID system that really complemented playing its role. And the number one most important thing would be that for the first time through the ICSID convention in 1966, individuals and individual enterprises could sue a government directly. And before that, you had the strictures of international law that meant you could only have one government taking action against another government. And so an investor who was frustrated by a government not living up to its commitments really had no recourse or no way to correct the situation. And the ICSID system set up basically an arbitration mechanism where the foreign investor was able to bring a case saying that the host government had not lived up to its obligations. And these obligations are sometimes found in a contract between the investor and the government, and more recently found in investment treaties. And there are a number of well-known treaties now, bilateral investment treaties and multilateral investment treaties. And often states are now putting investment obligations into their free trade agreements. And it is a potential breach of those obligations that can be the subject of a dispute at ICSID. So that is what the ICSID Center does. Throughout, from day one, ICSID was designed knowing that you needed to create a very careful balance between the interests of investors and the interests of host states. And because ICSID is the administering institution, it has to be very, very sensitive to making sure that investors and host states feel that they are coming into a system where there is a level playing field and a fair process. So that is very, very important to our credibility throughout. As well, in order to make sure that this was a depoliticized system, which was critical to making sure that it could fulfill its mission, the World Bank created a system where you had your arbitration or your tribunals all at ICSID and all within the ICSID system. And what's key about that is that you will never be going into the courts of the host state or the courts of the investor. So let's assume you had a Canadian investor who invested in Malaysia and the contract was allegedly breached. That investor would not go to the Canadian courts because Malaysia probably would not feel comfortable with that, nor would they go to Malaysian courts because the Canadian investor would not be likely to be comfortable with that. What you had was this independent system at the World Bank, which has this reputation for fair and impartial ability to administer the cases and is not any one nationality. So creating what's known as an autonomous and impartial system was absolutely critical to the success of the organization. The next piece that was also very unique and very important was the enforcement mechanism. Everybody knows that saying that there's no right without a remedy. In other words, if you have a right, you have to at some point have a remedy in case the right is not respected. And that really boils down to enforcement. And in this case, the convention set up a very simple system, which is part of the beauty of it, but a specialized system where an ICSID award was final and binding on the parties and could be simply enforced in all of the ICSID member states. And it's that enforcement feature that I think is the number one thing you hear about ICSID when you first start to look at the organization. In the treaty itself that all of our member states signed, they agree that they will comply with awards against them, and ICSID awards are final and binding. So there is no ability to go into a local court and appeal. It is final and binding. And there is a limited review within the ICSID mechanism called an annulment. But once you have that award and that decision, then the member states must recognize the monetary award without any further legal process. And if that doesn't happen, the award is enforceable as if it were a final judgment of any domestic court. And it is enforceable in the courts of any of the member states. Now, right now we have 156 member states. So essentially what that means is the ICSID award is automatically enforceable in each of those 156 member state courts. And that's a very important part of the process and very important to creating the stability of the system. Now, this you will see is a map of our 156 member states. And I think you can see just from a glance at it that basically we have coverage of all of the major economies and most of the economic activity in the globe, which is very important. I think the larger the scope of it, the more effective it is. And currently we have 156 member states, and those are the ones that are in blue on the map. We have 8 signatory states, which are the ones who are in yellow on the map, and then a further few, and I would say fairly few states that are not members. And as I always say, they are not yet members. We have found that we are getting about 1 to 2 new members every year, and so the organization continues to grow. Any state that is a member of the World Bank is entitled to join ICSID through a fairly simple process of signing the ICSID convention and then ratifying the ICSID convention. And unlike many other parts of the World Bank, there is absolutely no cost for a member state to join. In fact, they simply have to indicate their willingness and follow the process to get to ratification. And there is no annual fee or anything like that for ICSID member states. Instead, the way ICSID is funded is that where parties take advantage of and start a case, the parties will each pay ICSID a fee. And it's a fairly low fee, relatively speaking, for international investment disputes. And that is how ICSID is funded. And of course, it is a completely non-profit organization. So really, it is just to meet the ICSID costs and make sure that we can deliver a top-notch service for the clientele. Just to give you an idea of some of the members that have joined most recently, in July of 2020, Djibouti joined ICSID. And very interesting, in 2021, Ecuador joined ICSID. And one of the reasons I say this is very interesting is because there have been 3 states in our history that had ever decided to leave the ICSID convention, and one of them was Ecuador. And so when Ecuador rejoined in 2021, I think it was an especially happy or special moment for all of us at to see Ecuador becoming a part of ICSID again. So you will see there a photo from the signing ceremony where the Ecuadorian ambassador signed on behalf of her government to make Ecuador a member of ICSID. Now, ICSID itself is set up fairly simply, to be honest. It is not a complex organization. It is a small organization. It is probably the smallest of the 5 members of the World Bank. And essentially, you have 2 arms to the ICSID organization. You have what might be called the governance arm, which is our administrative council. And then you have the day-to-day arm, or the sort of actually addressing the function of the cases, and that is the ICSID secretariat, which is the group that I head up. And whoever comes to join us as counsel would actually be a counsel in the ICSID secretariat, where we do the day-to-day work on these cases. Now, the administrative council consists of 1 representative from each member state. And that representative votes on behalf of their state when there is some kind of an issue or a resolution put to the member states. That does not happen very often. The governance function is quite a light function, but from time to time, they are required to vote on certain new initiatives. And interestingly, just this week, we concluded very successfully a vote to amend the ICSID rules. And that was a great example of what the ICSID Administrative Council members had to vote on, and each country had a vote on those amendments. And at the end of the day, they were passed with great approval, which we were very pleased to see. The other types of governance issues that the members will play, for example, include approving the annual budget, approving the annual report, electing the Secretary General, and electing the Deputy Secretary Generals. One other very important role for the member states in the ICSID organization is that when a state becomes a member, it is entitled to designate 4 people as potential arbitrators and 4 people as potential conciliators. So essentially, you can think of this as people who are designated to go into a pool, and those people can be selected as individual cases arise. And this, I think, is a very important responsibility because it means, first of all, that states are able to make sure that qualified people are hearing the cases. They are able to advance people who come from their country and are in this field. And so it helps us to ensure a real global reach and global profile for the organization. So it's something that we are very proud to have, and it really helps reinforce the international character of the organization. Now, on the right-hand side of this diagram, you can see that it speaks to the ICSID secretariat. And if I may say so, this is where most of the functions happen. This is where the day-to-day work goes on. So we have at any one time about 300 or more investor-state disputes ongoing that we are administering from our secretariat. And we are organized into seven teams actually. We have 5 teams that deal with cases primarily, and they are each headed by a team lead. And then you will have a group of counsel, paralegals, and administrative assistants. And we have one team that is involved in what we call institutional matters. So for example, anything that is not specifically related to one case. So that group, for example, was very much involved in getting the vote and resolutions put forward on the amendments. Or if there is a state that wants to join ICSID, they're very much involved in liaising with them and helping to make sure the process goes smoothly. But of course, our number one job is this case administration. And so most of the secretariat is involved in that case administration. The other team that I should mention is our financial and administrative team. And I think most of you will know that for each arbitration and conciliation, we have essentially what you might think of almost as a bank account, or a place where we hold the funds to pay for the arbitrators, to pay for transcribers, those kinds of issues. And our administrative group takes care of all of those accounts, as well as the finances of ICSID and all of the administrative work that's involved in an international organization. Things like hiring and operational policies and all of those kinds of issues. So that is how we are structured. In terms of what we do in our mandate, as I say, the number one thing is the cases, supporting the proceedings from start to finish. And I'll talk in a moment about how we do that. But we have a number of other functions that we play on top of that case management role. And one that's become very important is training about investment law and procedure and about ICSID, and providing technical assistance. And to give you a good example of something that's ongoing now, recently we've been providing a lot of technical assistance about mediating investor-state disputes, which is something that is probably newer to the discipline, and people are starting to learn, how do I do this? In what circumstances would I want to mediate? And what are the best ways to have a successful mediation? So there, for example, is one of the types of technical assistance that we provide. And certainly all of our counsel, while they are mainly involved in cases, they also contribute to doing the training and the technical assistance. And I can say, I think a lot of our staff really enjoy doing that, because it's a chance to really get to know all sorts of people in the professional stream who are involved in this area. So our council really enjoy doing the training and technical assistance. We also have a publications program. And as part of that publications program, we, from time to time, will publish books. But the key part to that is publication of what's known as the Foreign Investment Law Journal. And that is, again, the premier law journal on issues related to international investment law. And we publish that 3 times a year. So you can see that basically ICSID is a hub for all things international investment law, and very much the premier center with respect to that field of endeavor. Now, our staff, you can see here, come from all over the world. And I think one of the most wonderful things about ICSID is it is truly an international organization, and we offer services around the world. We have 3 official languages, English, French, and Spanish. And as well, many of our cases will involve, for example, witnesses or counsel who are speaking other languages. And so we have all sorts of really good translators. And so it truly is a very international organization. We are headquartered in Washington, D.C., and we are in a lovely new building that we moved to about 3 years ago, where we were able to set up our own in-house courtrooms, essentially, with all of the technology you would expect, as well as our offices for our secretariat. So there, for example, you can see this is a number of our staff in one of our libraries on our C building headquarters. And we're really very, very privileged to have these facilities. They are absolutely fantastic for hearings. Now, I wanted to focus a little bit more on the case administration because, as I said, that is the number one job that we do and the number one focus of our organization and of the work. In terms of case administration, for every case that comes to ICSID, you will appoint one of our counsel as the tribunal secretary. And the tribunal secretary essentially will work on the file with the parties, the claimant and the respondent, as well as with the tribunal to make sure that it goes smoothly all the way through the process. So what that means, for example, is that we start with the request for arbitration, which is essentially a screen to make sure that the case would be within the jurisdiction of ICSID. And our counsel will go through all of the materials and give me advice on whether we should register the case. And once we register the case, we get into the process of selecting a tribunal. Most tribunals now are three-person tribunals. You will have frequently one tribunal member appointed by each of the parties, and then the parties jointly appointing the presiding or the president of the tribunal. Where the parties are unable to do that or unable to agree, which sometimes happens in particular with the president of the tribunal, they may come to ICSID and ask us if we will select an arbitrator to be the presiding arbitrator. So that is one of the functions that the tribunal secretary would work on with me. We would go through and look at who might be a good candidate, who has the right nationality, because you can never judge a case which involves a country or a claimant from your own country. Do they have the expertise? Do they have the linguistic skills? And making sure they do not have any kind of a conflict of interest. So that would be a role of the tribunal secretary. Ultimately, you end up getting your three-person tribunal together and constituting the tribunal, and they have what's known as their first session, where they essentially decide, how is this going to work? We have the overarching rules, but for example, what are the pleadings that will have to be delivered here? And when can we have our first hearing? And do we want the hearing in Washington or in Paris or in Tokyo? There are all sorts of those sort of running mechanisms that are important, and that will be decided at the first session. And that first session is one that our tribunal secretary organizes and helps the tribunal to run. And from that point onward, the tribunal secretary works especially with the tribunal to make sure that they have the materials that they need. Sometimes they will ask the secretary in particular for procedural advice because our secretaries know this area of the law and in particular the procedure better than anybody. And they will sit through the hearings with the tribunal. Ultimately, they will sit through the deliberations with the tribunal, and they will help to make sure that the award is issued. As you know, along the way from constituting a tribunal to getting a final award, there are often a number of interlocutory motions, things like requests for provisional measures or security for costs or consolidation of cases. All of those kinds of things are issues that the tribunal secretary will work on with the tribunal. So it really requires a lot of knowledge about the field, and in turn, it really develops a true expertise in this area. So that's essentially the case administration role of our tribunal secretaries. They are also there to help the parties. And obviously, while we don't give legal advice to the parties, ICSID proceedings are something that often is new to both claimants and to respondents. And so our policy and our approach is to be as helpful as possible to the parties. So it's quite usual for the parties to ask the tribunal secretary, what is the next process, or can you direct us to any resources for us, or how does this normally work? So they very much are a resource both for the tribunal and for the parties. When we talk about the cases, there are a number of different types of procedures that are available. Most of the cases are arbitration, and that's because the parties usually select to have an arbitration. But there are also a number of cases that are conciliation. And interestingly, as a result of the new amendments that went through this week, we are starting to do investor state mediation and investor state fact finding. So there are a number of different legal processes or legal tools that we offer to the parties and that our counsel will work on. As well, there are a set of rules under the ICSID Convention, which we spoke about early on in the presentation, but we also have a separate set of rules for parties that are not from a state that's an ICSID member, and those are called the Additional Facility Rules. In addition, there are some ad hoc rules that you may well be familiar with, the UNCITRAL rules, and we will administer investment cases under those rules, as well as ad hoc cases dealing with investment disputes. We're also available for specific things, for example, acting as an appointing authority or acting as a registry for these kinds of cases. So all of these roles are ones that are played by the ICSID Secretariat, and the secretaries are, of course, a key part of that. Now, the conduct of an ICSID case is one, I think, that in many ways almost resembles a court-like process, or if you've been involved in arbitration, is very much similar to many arbitration processes, with the exception of the fact that the first step is to register the request. I don't know of any other arbitration process that requires parties to apply for registration before they can actually start the original case. And this was one of the features actually built in to the convention in 1966 to make sure that you did not have cases launched that were not within jurisdiction, or that just simply wouldn't have a hope of succeeding. And so none of the parties should be put to the time or cost of a case. But after that registration process, the process becomes one that you're probably familiar with if you do arbitration work. And that is, of course, selecting the arbitrators, then having the proceedings, usually written proceedings, followed by oral hearings, ultimately getting an award issued by the tribunal. And then there is the potential for a very limited number of review mechanisms thereafter. And then the award, of course, is enforced in various jurisdictions where the parties would like to pursue enforcement. In terms of caseload, you will see that the caseload has been going up significantly, especially in the 1990s. And that very much reflects what was going on in terms of investment policy in a number of states. In the early years, most of the disputes arose from contracts, things like a concession contract or a permit, things like that, where a state would have a contract directly with the individual investor who came into your state. What we started to see was the growth, especially from the 1990s onward, of international investment treaties. And almost all of those international investment treaties have a clause that says if a party thinks there has been a breach of the treaty, they may have that breach adjudicated at ICSID. So you can see that that led to an increase in the number of cases at ICSID steadily over time. And it's led to where we are today. For example, in 2020 and 2021, in each of those years, we had a new record for the number of cases administered. So on average now, we're getting about 55 to 60 new cases per year at the center. So we're seeing real use of investor state arbitration, and it is a field that very clearly is growing. And that is also shown not just at ICSID, and you've just seen the case numbers at ICSID, but more generally. And so this chart tells us essentially that while most of the cases are at ICSID, we know generally that investor state is a mechanism that is on the rise. And we know it's a mechanism that's on the rise in all regions of the world. So this is a very busy place these days. Now, in terms of the role of counsel, we've talked about it a little bit. Of course, the main role being casework, and we've talked a bit about the casework and what that involves. We've also talked a bit about outreach, but one of the things I thought would be interesting to talk about is some of the ongoing projects. And again, we have our tribunal secretaries, our counsel, involved in all of those because they do have the expertise. So for example, we have just finished this large amendment of our rules, and that was something that all of our tribunal secretaries were involved in. We are also now involved in a joint endeavor with UNCITRAL to develop a code of conduct for arbitrators that ideally would be a universal code for all investor state arbitration. So we have a lot of those kinds of projects that relate to an expertise or need the expertise in the field and really rely on counsel's expertise to make them very targeted to investor state dispute settlement. This is simply just an example of the kind of outreach that we do, and two of my colleagues from ICSID who were giving a course that we often gave, which was basically an introduction to ICSID. We also, of course, have these institutional projects, which I've already mentioned this morning. And so I wanted to basically close with just telling you a little bit about the environment at ICSID and why it would be something that I think would be a very exciting opportunity for anyone who wanted to do the council work with us. This particular position where we are recruiting somebody from Japan is one that I think is very, very exciting, certainly for ICSID, and it certainly reinforces our view that we are a global organization and we operate all around the world. And so we want counsel and staff from all around the world. But I think for whoever does this job, it's also a really exciting opportunity because you will come and be literally in the middle of this world. You first of all will be at the World Bank, which is an incredibly interesting international environment. When you come to the World Bank headquarters, you see people from everywhere and you hear all sorts of languages around you, and you realize you are truly in the middle of a very exciting international organization. Our group is a small group, but it is a very cohesive and collegial group of people. And I'm so proud that people are very, very happy working at ICSID. We work on very exciting work in a very specialized field, and we are small enough that we know each other very, very well and are very much like a family. As an ICSID counsel, you will have individual responsibility for your cases. You will be in a team of colleagues, and you will have a very knowledgeable mentor. One of the more experienced counsel will be your mentor. You will have a team lead who also helps you learn the work of the center and how to undertake your role, and then 2 deputy secretary generals and myself. So there is a lot of effort put into making sure that every counsel learns the field very well, learns how we approach cases, and really develops their full potential and full expertise in the investor state discipline. Our cases are very much in this new and growing area of law. So you will find that you are right in the middle of a case which all of a sudden is being discussed by academics and by practitioners. And you were the one who was involved in this case from day one. I think it's very interesting because you really understand what goes into a case and you really develop your expertise because you are right there. Related to that, one of the most lovely things about working at the center is you will be working with very well-known jurists, well-known arbitrators, the best of the best counsel, and state officials who are involved in investment protection and investment promotion. So once again, you're involved with those who truly know the field, and you are seeing the expertise and how it all comes together. And one of my staff once said, this is like being on the other side of the looking glass. And I thought that was a really good way to summarize what it is like. As well, you will be involved in shaping reform, and there's no better example than this set of amendments that we've just passed, where all of our staff were helping us put proposals forward to the states and refine those proposals and refine the drafting. So that is why, for example, many people find this the place to be if you are interested in international investment law. As part of the characteristics of employment, you can understand that where you are an employee of this impartial organization, it's absolutely vital for you to maintain that strict neutrality. So, for example, we will never make a comment that we think a case was rightly decided or wrongly decided. We would never tell a party we thought they were arguing a case poorly or well. We are the ones there to make sure that the process works, and we have to maintain our very strict neutrality to make sure that we maintain our credibility and that parties maintain their confidence that they are somewhere where they will be treated fairly and their case will be dealt with appropriately. Again, related to that, you are assisting the process, but you are not the decision maker. So it is not, for example, for an ICSID secretary to say to the tribunal, here's what you should decide. We would never, never do that. What we do is we will certainly provide them with the kind of information they need or they request. So we will help them, for example, provide information, find information in the transcript, or if they want to know how a certain procedure has been implemented in the past, we have that expertise. So it's really a very unique role that you play as a tribunal secretary. And you don't have any one client, and in fact, maybe it's not even right to use the word client, but you are certainly in the service of the member states who are acting as respondents, the parties who are acting as claimants with their representatives, and the arbitrators who are deciding the case. So that's a little bit about ICSID and acting as a tribunal secretary at ICSID. And I've put together here a number of other resources. We have a tremendous website which has unlimited resources, and in particular talks quite clearly to the various steps in a procedure. So I've provided this for you in case you wanted to do any further reading. And our website, of course, is here, and it's fairly easy to get to, but I think it will give you also a lot of other information about the center that might be of interest. So that's a bit of an introduction to ICSID as an organization and to the role of the tribunal secretary. And I would be absolutely delighted to answer any questions that anybody might have about ICSID and the work we do.
Thank you, Meg, for your keynote presentation. Really inspiring, and I'm sure potential candidates will be further inspired and persuaded that they really need to apply the ICSID position this time in order to be part of the entire endeavor, which is growing actually, as I heard.
Exactly.
But also, your presentation really enhanced the broader understanding on what ICSID does, and also how in a sense, World Bank Group as an institution working together for the common purpose, the goal of the that ahead of us. Let me before moving into the reading the question that we received, let me raise one question, which is something that we talked a little bit about before starting the session in an informal way, about the impact of COVID on the ICSID operations. You mentioned that you have 67 members in the secretariat headquartered in Washington, D.C. Now, because of the COVID as an impact, how does it affect on the day-to-day operations of your team? Location of the staff, telecommuting from other places, and also as we are now moving gradually to the next stage of the COVID to the, in a sense, new normal way of operating things. So how do you see the ICSID operations in near future?
Very interesting because before COVID, we certainly could do hearings using remote platforms. It wasn't something that parties often wanted to do, but it was always available. And before COVID, we were planning as part of our amendments to make all filing electronic because anyone who's been at the secretariat in the old days saw people bringing in forests worth of bankers' boxes of materials and papers and us trying to store them. And so we were very much trying to move towards the paperless world. But as lawyers, we like our paper. And so this was a slow effort. And COVID, in an interesting way, had a good impact on that, in that all of a sudden we had to go fully remote. And what that meant was almost overnight, we had to say to parties, all materials will be filed electronically and all hearings will be done remotely. And so we got very, very expert very quickly at holding remote hearings. And it was interesting because the entire arbitration field, I think, was learning this and getting better at this skill because we all had to. But what we all discovered in the course of it was that we could very well hold hearings. And I can tell you that we've done more than 500 remote sessions since COVID began. We have had hearings with arbitrators in 3 different locations, counsel in multiple locations, witnesses sometimes sitting at their kitchen table, but we've been able to manage that technologically incredibly well. I have to say, very impressed with that. And what we've all found is that there has been a savings in time and cost from that. We're not all coming to a location and bringing our staff and staying in hotels and spending weeks doing a hearing. We can do this remotely. And so I think the arbitration profession, including ICSID, has really actually been sort of forever changed or maybe pushed forward a little bit because of our experience during COVID. So the stage we're going into now is one essentially where things will be hybrid. We are offering the remote platform for parties, and I think parties will want to use that in many instances, but there will be times where parties still want to have a hearing in person, likely, especially when there is a witness, they will want them there to see them, to have cross-examination. So we are moving into, I think, a remote and in-person hybrid environment for our hearings. Similarly, for our staff, we had always talked about, could you do home-based work? And all of a sudden, COVID made us all do home-based work. And we realized we actually can do home-based work quite well. And so there will still be opportunities for some home-based work for all of our staff, but certainly we will want them in the office sort of a couple of days a week. And if you had a hearing, you will have to be in the office for that whole hearing. And I think in many ways, for the development of staff and just the development of collegiality, it's nice to be in the office at least some of the time. So for now, what we're trying to do is make sure that people can have the option of working at home, where you need that time to do that focused work, but also will be in the office to be part of that atmosphere and to provide the service to parties and arbitrators that we're renowned for. So COVID has sort of pushed us forward in some ways, in a very good way.
Great, thank you. Thank you for your responses. So let me read the questions that we received in advance to the seminar. Some of them you already mentioned, but let me read those questions as these are the questions that we received from our audience. The first one, how does the work of ICSID stand within the World Bank Group? For example, in terms of percentage of workload, size of operations. How does ICSID contribute to the poverty reduction and economic growth of developing countries? Meg, probably, you mentioned towards the end of your presentation, ICSID cases are really increasing in the last 20 years. So it'd be great if you can touch upon, this question from the viewpoint of increasing business of ICSID in the last 20 years, and then how the role of the developing countries played, in those increasing tradition, the trend. Thank you.
Exactly. Exactly. Well, as I say, it all relates to the bigger mission of eradicating poverty and increasing shared prosperity. But the way ICSID comes into it is quite different than the rest of the World Bank, because what we are doing is trying to make sure there are positive investment climates. And one of the things we all know is that uh, it is a disincentive to invest somewhere if there's, for example, arbitrary conduct, if you can be expropriated without compensation, if the courts do not treat you fairly because you are a foreigner. And we know from many, many case studies that those are the kinds of things that can happen. And when they happen, they create a negative investment climate, and it makes it very difficult for states to get investors into their country, bringing, jobs, technology, all of the things that you would look for. So these investment treaties in particular, but also investment contracts, have been used, first of all, to set a standard. States promise, for example, they will not expropriate without compensation. And there is the ICSID mechanism, if that does happen, to actually hold them accountable for that kind of conduct. And interestingly, what we found is certainly that's clearly effective in the case where there is a breach. But what we might also not think of, but which is also very true, is that this also helps in a way to be preventive. That states, once they have made those promises, will make sure, or will try very hard to make sure those kinds of things don't happen. And so that in and of itself helps reinforce a strong investment climate. So that's really how ICSID feeds into the bigger picture. In terms of the increase in work, it is something that's a very interesting phenomenon. First of all, I think generally there has been an increase in arbitration. And that's not just investment arbitration, but also commercial arbitration between private parties. And we have also seen states increasingly use these investment treaties as a mechanism for investment promotion and also protection of their own investors going abroad. So this is a set of tools that are increasingly used by states. I think the statistic roughly is more than 180 states have at least one or more of these investment treaties, and a number of states have many of them. I think China has more than 145 of these kind of treaties. So they very much are part of the whole investment promotion world. And they really help to protect, in particular, against political risk. And ICSID plays a huge role in making sure that those promises are lived up to.
Thank you very much. Next question. My question is about the knowledge management at the ICSID Secretariat. As one of the most trusted editorial institutions since its establishment, I'm sure the ICSID has been making every effort daily to provide support for the fair, smooth, and expeditious conduct of the arbitration proceedings. In case of ICSID, I assume the Secretariat has accumulated knowledge and expertise about jurisprudence of international investment law and public international law, as well as the best practices of arbitration proceedings based on particular arbitration rules. In this regard, I would appreciate if you would tell us how the Secretary is working on the internal knowledge sharing, for example, in order to efficiently share each council insight and experiences with other team members within the Secretariat. I read actually the entire question because that was a well written question. So
Yeah,
I'll ask, yeah, please. Thank you.
So I think obviously there's almost two sides to that. The first would be knowledge sharing with the outside world. The people within the ICSID Secretariat are very much experts and see all of this firsthand. And so one of our roles really is knowledge sharing with practitioners, with students, with state officials. And we do that through a lot of technical assistance. We must do more than 200 presentations a year. Here's what a hearing looks like. here's what to expect, here's the case law. We're also very proud of being what in investor state is known as transparent. We have, for example, a website where you can go and see at any one time what cases are being heard at ICSID, and each of those cases will have a listing of who are the parties, who are the arbitrators, and when a new decision comes out, that decision is hyperlinked. So you can read, why did they decide to give a provisional measure in any one case? And we keep a running procedural order so that you can see what's happening in that case. Oh, there's a hearing next week. A number of our cases actually are done publicly. In some instances, people will come to the center to watch the case. And more recently, again, here's a use of technology, but more recently, we have webcast a number of these hearings. So there is a lot of effort to share the knowledge with the outside world. In terms of inside, within the center, we do a lot of work to make sure that we all have the knowledge and the expertise, and to ensure that we are acting in accordance with best practices and acting consistently. So we have a whole computer system within. We have a series of what we call best practices and templates, and we have a number of discussions and presentations every week where, for example, one of your colleagues would say, this is what happened this week. Here's a new situation. Has anybody had that happen? And we'll discuss. And there's all sorts of institutional knowledge among our people. Or one of your colleagues will say, a new decision came out, and this is a different approach to a certain problem. Here's what it is. So just by being in the environment, we make sure that we share all of that knowledge and that our council are able to really be at the leading edge. And we have all sorts of internal IT systems, obviously, that support that. But more than anything, I think it is having the colleagues together who do this 24/7 that makes it really a very enriched experience.
Great. Thank you. As we are running out of time, let me raise one set of questions and ask you the final remarks. The question is this. These are the rather questions which are beyond the current Japanese National Recruitment Program. But the first question is ICSID planning to hire non-legal positions? So that's one. And the other one is, are you making any special effort or making unique features in hiring process at ICSID? So probably these are the questions that are going beyond the current Japanese National Recruitment Program of those who may unfortunately miss the opportunity this time, but in the future thinking about the potential opportunities at ICSID. That's one set of questions. The last point I would like to ask you is really to share your final remarks to Japanese audience or audience in Japan, particularly those who are thinking about the applying this time. Thank you.
Absolutely. We do not have many non-legal positions because of what we do. So we are not hiring non-legal staff right now, but from time to time, those positions do come up, and we always advertise them. For example, in our financial group, our administrative group, those come up from time to time. Our paralegal positions come up. So there are opportunities from time to time, although right now we are looking at the council role. In terms of our efforts, in terms of the hiring process, we have always recruited internationally. And so we are looking for a diverse group of people who can operate in a very international environment with a very unique specialty of international law. So we put a lot of effort into the hiring process, and then a lot of effort into making sure that we train whoever the new council is so that they really get the full experience. Now, sorry, your third question, I've forgotten that now.
Yeah, the very final remarks for those who are thinking about applying this time.
That's the most important one. Thank you. I certainly know that this would be wonderful for us. we really do pride ourselves on having a very international environment. And so there's no doubt from an ICSID perspective, it would be wonderful. But what I want to speak to mostly is what an opportunity it would be for a council. I think if you're a council who would like to learn about this area and who would like to have a career in it, there truly is no better place to get training and exposure and knowledge. By being at ICSID, you are right in the middle of the cases. You're in the middle of the cases that are ongoing. So it is the newest of the new. You are in the middle of a group of people who are expert. And every day we see new and different legal issues that we might not have expected. And if this is what you want to do as your career, it is a very, very exciting thing. And I think once you've done a couple of years at ICSID, anybody is going to say this person really knows and has seen this field of law. So it is a tremendous opportunity for a council to start a career in investor state and really grow and blossom. So I think it would be obviously a win-win, but if you're interested in the area, I would highly encourage you to put an application in. You will also enjoy not just the legal part, but really very exciting to be in Washington, to be in the World Bank, to be in a truly international environment is really a unique privilege. So I can only say 100% good things about it.
Thank you very much. We had a pleasure of having Meg Kinnear, Secretary General of ICSID, International Center for Settlement of Investment Dispute, one of the 5 institutions of the World Bank Group, this morning connecting from Washington. Meg, thank you very much for your time.
Thank you. Good night.
Great, thank you. All right, we have interesting online seminars coming up. For example, we will be featuring World Development Report 2022, Finance for an Equitable Recovery, featuring its director, Leona Clapper. This will be held in April. So once we fix the date, we will announce it on our website. And also details of Japanese national recruitment programs, including TORs of 15 positions. Please check the World Bank Tokyo office website and please do apply. With that, thank you very much for watching. Stay safe, stay healthy. See you next time. Thank you very much.